Do we know where Mr. Morial is? He's not here. The committee will return to order. Senator Cornyn, you're recognized.
Thank you, Madam Chairman. I was just complimenting Senator Blackburn on her rapid ascension to chairman of the committee. I've been on the committee for 16 years, and I haven't quite made it there, so congratulations. Well, thank you all for coming and sharing your views. I can't help but comment on the stark differences that we're hearing from the various witnesses about this particular nominee. He's either the most qualified person you could ever find, or he is the least qualified person, and there doesn't seem to be much room in between. But let me ask some specific questions. First, I want to talk a second about criminal justice reform, because it strikes me that of all the topics that we've dealt with here recently, that's one of the areas that brings us together. And I'll just reflect, Mr. Johnson, I remember being in Dallas, Texas, maybe 10, 12 years ago. I was visiting with a number of African-American pastors, and I asked them, I said, what's the biggest problem in your congregation? And they said, well, it's formerly incarcerated men who have a felony on their record, and it's they can't find a job, and they can't find a place to live. And that's sort of always haunted me a little bit. But in light of some of the great work that's been done at the state level on prison reform, and I would have to say I'm proud of the efforts made in Texas and elsewhere to try to provide people opportunities when they are incarcerated, those who are willing to accept responsibility for their own rehabilitation. We've had some remarkable successes and people who have taken advantage of the opportunity to turn their lives around. And I think our view as a government and as a people has changed significantly. Mr. Barr talked about 1992 and the violent crime back then, and that there was a different attitude. And I think we've learned from our experience. But I want to go, General Mukasey, one of the things that you testified to, I think in a previous Congress when we were talking about criminal justice reform, you said that really the test, the ultimate test for the success of criminal justice reform is the crime rate. I think I'm quoting you correctly. Could you explain that? Because there are a lot of people who want to focus on other things like incarceration rates and other issues, but the crime rate, it strikes me, public safety strikes me as the most important one.
Yeah, I think that is the ultimate test for the statute that's just been passed and for future statutes. What does it do to the crime rate? The criminal justice system is there in substantial part to protect the public. If it's doing that and the crime rate is dropping, then bravo to the experience. And to a certain extent, it's going to be an experiment. Mm-hmm. We'll see how people do when they get out. We'll see how much money is saved and what it can be directed toward by way of prevention. And hopefully our situation will improve.
Well, fortunately, in the criminal justice field, we have actually used the states as the laboratories of democracy, and we tried this out before we've implemented at the national level. And I think we've benefited from those state-based experiences. In my state, for example, we've reduced not only the crime rate, but the recidivism rate, and we've closed plans to build new prisons to incarcerate more people. So it really strikes me as something that it's one of those unusual scenarios where basically we were able to come together, people of dramatically different ideology and orientation, and come together and do something very positive for the country. And we're going to keep an eye on the crime rate, to me, is the litmus test of the success of what we try to do. Professor Turley, I wanted to just, first of all, compliment you on your article that you wrote in The Hill. And just preface that, the title, of course, was Witch Hunt or Mole Hunt? Times bombshell blows up all theories. I've been extraordinarily troubled, frankly, by the politicalization of the Department of Justice, including the FBI. And I think you pretty much, in this polarized world we're living in, you talk about cognitive bias. And depending on the lens you're looking through, you can see a narrative, you can build a narrative that tells your story. Would you take a minute to sort of explain the thesis of your article and the views you expressed there?
Thank you, Senator. What I thought was most interesting about the New York Times article was actually not the point of the article, which was that the president may have been investigated under the suspicion that he could be an agent of a foreign power. But what came out to me from the article was an insight into what and how the FBI was looking at this early in the Trump administration. And we also have an insight at how the Trump administration was viewing what the FBI was doing. And this gets to the issue of cognitive bias, that it's a well-known concept that you can look at a problem with a bias where you see things that reaffirm your suspicions. But in this case, the FBI moved early on with an investigation that the White House was aware of. That fulfilled the White House's own bias, that this was a deep state conspiracy, and the White House pushed back. And when the White House pushed back, it fulfilled the cognitive bias of the FBI, that they're trying to hide something. And if you take a look at the timeline, you see this action and reaction occurring where each side is reaffirmed by the actions of the other side. So what the column raises is a distinct possibility that we might not have Russian collusion or a deep state conspiracy, that we may have two sides that are fulfilling each other's narrative. And we've gone so far down this road that it's impossible now to stop and say, well, what if neither of these things actually did exist? In economics, it's called pathway dependence, that you can invest so much into a single path that you can no longer break from it. And so what the column is suggesting is that perhaps we can actually use these stories and take a step back. And instead of assuming the worst motivations by both sides, look at this as whether both sides were trying to do what they thought was right or reacting to what they thought was correct, but they might have both been wrong.
Madam Chairman, my time's up. Could I take one more minute?
Yes, without objection.
Yesterday, I was asking Mr. Barr about Rod Rosenstein's memo that's entitled Restoring Public Confidence in the FBI. And to me, one of the most encouraging things about Mr. Barr's appointment is I think he's exactly the kind of person who could do that, having done this 27 years ago and being willing to do it again for no other reason than his desire to help restore confidence in the Department of Justice and the FBI. So. But if you go back even further, back when James Comey was and the FBI were investigating Hillary Clinton's email server, and he took the unprecedented step of having a press conference on July the 7th, 2016, at which he essentially exonerated Ms. Clinton while detailing all the derogatory information in the investigation, and then later on had to come back because of that press conference when the Wiener laptop was identified and say, hey, we found some more emails. The idea that the FBI and the Department of Justice would become so tangled up in an election and potentially influence an election is really unprecedented in our country and very dangerous from my perspective. And then, of course, when Mr. Comey was fired by the president, then folks on the left thought he was St. James. And after he had been the devil, I guess, previously when he was investigating Ms. Clinton. So I do think there is some of that cognitive bias going on here, and we need to identify it and maybe step back from it and learn from it. Thank you, Madam Chairman.
Senator Harana.
Thank you, Madam Chair. Reverend Risher, I too have had the opportunity to meet with some of the survivors of that tragic day, and so thank you very much for your heartfelt reminder of the work that remains for us to do. Professor Kinkoff, you've written a lot about the unitary executive, and that's something that Mr. Barr subscribes to. So I found it really interesting what you mentioned today, because there were a lot of questions from so many of us seeking reassurances from Mr. Barr that he would not interfere with the Mueller investigation in any way, shape, or form. And today, though, you said those assurances are irrelevant because under the unitary executive theory, that if Mr. Barr were asked, can the president fire Mr. Mueller, Mr. Barr would say yes. So there goes the entire investigation. I found that to be a really interesting statement on your part. So that means that, so let's say that if the president does fire Mueller, and one would say that under a normal circumstance, that kind of firing could be part and parcel of an obstruction of justice kind of an investigation. But if the entire underlying investigation goes away because the investigator is fired, then where are we? So that's very interesting as we sought to seek the kind of reassurances that would enable us to feel that the Mueller investigation is, in fact, going to be able to proceed. So you talked a little bit about what the impact of the unitary executive, and I do, that theory, and I do understand that there's a range. It's not, you know, there's a continuum there. So I just want to ask, under the unitary executive theory, can a president commit obstruction of justice with impunity?
So I'll answer based on the memo that
yes.
Mr. Barr wrote last summer, because as you say,
Yes.
there's a range, and so the answer would be different depending where you are on the range. The Barr memo allows that there may be circumstances where a president can be understood to have committed obstruction of justice. Now, that's different from saying the president can be charged with obstruction of justice, and in fact, Mr. Barr yesterday during his testimony said he sees no reason to deviate from the department's policy that a sitting president can't be indicted. But even within that construct, that a president can commit obstruction of justice, it's really difficult to see on his theory how that would end up happening. Because he says when the president exercises a legitimate executive power, that cannot provide the basis for an obstruction of justice charge. And therefore, if he exercises his authority to fire someone, James Comey is the discussion in the memo, then that cannot be the basis of an obstruction of justice charge. If President Trump then used his authority to fire Mueller, that, by extension, wouldn't be something that could serve as the basis of an obstruction of justice charge on the theory set forth in the memo. And I think he should be at least asked in follow-up questions whether or not he would apply the logic of the memo to that situation. And he should be asked, if that were to transpire, would he resign? Because I think yesterday he indicated that that would be an abuse of power. And that's something an attorney general should resign if the attorney general sees.
I think you have given us a further line of questions to submit to Mr. Barr. Regarding the Voting Rights Act, so this is for Mr. Johnson and Mr. Muriel. We know that after the Shelby County decision, there were many states that passed all kinds of legislation that would be considered by a lot of us as voter suppression. And yesterday, Mr. Barr testified that he would vigorously enforce the Voting Rights Act, the Section 2 of the Voting Rights Act, to the two of you. Since there has not been a single Section 2 proceeding brought by the Justice Department, what specifically could Mr. Barr, what would you want Mr. Barr to do to vigorously enforce the Voting Rights Act as he testified yesterday?
I think, number one, that he should review the decision by the Justice Department to switch sides in these two cases. One has been resolved. Number two, he should ask the voting section of the Civil Rights Division to present to him all instances where the Justice Department has been asked to initiate Section 2 claims. Number three, I believe that he should investigate, evaluate, and review those states that have passed voter suppression laws to determine whether, in fact, they are discriminatory, and, in fact, if they're discriminatory, to initiate a Section 2 claim. The issue is for the Attorney General, and there are many competent lawyers in the Civil Rights Division at Justice, to do their job without political interference, to make recommendations to him on what steps should be taken. A lot of stuff has been put into the deep freeze in the Sessions administration because he was just not interested at all in enforcing the Voting Rights Act because he disagreed with the Voting Rights Act and had had a long career of disagreeing with the Voting Rights Act. Well, the Attorney General does not have an option to pick or choose which laws they want to enforce. They must enforce all laws that are vigorously, because it's your job as the legislative branch to pass those laws. So I think that there are a number of things that the Attorney General can do, and most importantly, to publicly state that he will not follow the policy of Attorney General Sessions when it comes to the entire realm of civil rights. It's important for him to be on the record, as forceful as possible, but also to commit to take the necessary steps to ensure that Section 2 is vigorously enforced, and also to look at those instances where the Justice Department has either switched sides or refused to take a position. The case I mentioned earlier in my testimony, the Chisholm case, which was a judicial reapportionment case in which I was a plaintiff. The case was brought in 1985. It was decided by the Supreme Court in 1991, was a case where the Justice Department sided with us during the Reagan administration. And so the consistency of the Justice Department in taking an affirmative stand in voting rights cases in support of those who've been aggrieved is something that until the Sessions administration was a bipartisan matter. And I think that this nominee should be asked whether he is going to restore that emphasis and that integrity to the enforcement of the Voting Rights Act.
Madam Chair, I'd like to ask Mr. Johnson to respond.
I agree with my colleague, but I also think he should intervene in current litigation. There are several ongoing voting rights cases that's taking place across the country. Secondly, he should work to fix the issue around Section 5. The House Special Committee on Voting Rights Act will be doing hearings across the country, as from my understanding. And if he becomes the Attorney General, he should seek to also support a fix in terms of Section 5. And then thirdly, review formerly covered jurisdictions to see if, in fact, they've made changes in their policies, practices, or procedures, and if those changes were, in fact, vote suppression methods, so we can document the record to show that without a proactive Justice Department and law, jurisdictions will revert back to past practices of discriminatory actions.
Thank you.
Recognize myself for questions at this time. And Mr. Turley, I'd like to come to you first. You spoke last December at the Press Club about privacy rights and security in a world with changing technology and the rising use of artificial intelligence and facial recognition technology and the challenges that is going to pose for the Justice Department. I think we all realize they're going to be there and will have to be confronted. And no clear answers have emerged at this point as to who owns the virtual you and your presence online. And more now, on a daily basis, we're hearing from consumers who are wanting to make certain that there are privacy protections in a digital world and in that virtual space, and that they're for everybody and that everybody plays for the rules. So Mr. Barr is going to have to address these issues because it is going to require greater enforcement from the Attorney General. And I'd like to hear from you on the role that you see the Department of Justice under Mr. Barr's leadership playing as we deal with companies like Twitter and Facebook and some of these edge providers in the technology space.
Thank you, Senator. Of those emerging areas, facial recognition technology is probably the fastest moving and the one that has to be addressed the soonest. I've already spoken with people at the Justice Department and to see if there is any way that the privacy community and the government and private industry could find common ground here. I think that for privacy advocates, we can no longer just simply say that all facial recognition technology is an evil and we're not going to work with it. Part of the reason is that the Fourth Amendment controls the government. It doesn't control private businesses. And this market has progressed to the point that you are not going to get that cat to walk backwards. I mean, this is an emerging market. The Chinese have put a huge amount of investment in it. If you just land at Shanghai, you'll see what facial technology is going to look like across around the world. So the question is, how do we then marry the privacy values that we have with the legitimate security interests of the government? And the answer is there's a couple of things that we can do. And one is that most of this technology is going to require a data bank to be used effectively, including facial recognition data. We can act proactively to try to create privacy protections for the access of that information, how long that information can be stored, for what reasons it can be used. We need to really get ahead of this. And frankly, Bill Barr is a perfect person to do this because not only does he have really the law enforcement chops in terms of understanding how technology is used, but he has spent a lot of time in private business at the highest level. And so I can't imagine anyone better on this issue, quite frankly, to tackle it.
Mr. Thompson, let me come to you with another technology question because last fall DOJ met with some of our states' attorneys general to talk about the frustrations with Google and Amazon and some of these edge providers and their failure to protect consumer data and also their anti-competitive behavior. And one of the things that came out of this was how Google prioritizes search results, theirs, to give them a competitive advantage over Yelp. So we know that these challenges are only going to be resolved if there is a multifaceted strategy that includes a partnership with our state's attorneys general. And if there is enforcement by the antitrust division and consumer protection branch. So with that in mind, how would you advise Mr. Barr, or how do you see him moving forward at DOJ to deal with big tech and these issues that they're really confronting consumers every day?
What I see with respect to your question, Senator, is that this is something, number one, that I really do not know a lot about this, but I think the Attorney General, nominee, if he is selected, would come in and review with career Department of Justice lawyers and others, professionals in the department on issue, review the issues, listen to them carefully. This is what he has done on other issues of import. But more importantly to your question is that I think he has great experience in the past of working with joint task forces, joint efforts with state and local authorities, especially the state AGs, and he knows how to do this. He has done it successfully in the past, and I think he would be able to work with our state law enforcement colleagues and get at the answers that are raised in your question. Very important matters.
In the minute that I have left, and before I yield, Mr. Blumenthal will be next, I just want to thank each of you for being here. And Reverend Reicher, I want to thank you for your testimony. And I came to the Senate from the House, and we have passed some of the red flags legislation that Senator Graham had mentioned that he is working on here in the Senate. We look forward to some of those steps being taken, and I know that is something that's important to you. And Mr. Canterbury, we always thank you for the work you do for the Thin Blue Line.
Thank you.
And the good work that you all are doing there. My time has expired. Senator Harris, you are actually next. You're recognized.
Thank you. I appreciate that. And thank you, Senator Blumenthal. Mr. Morial, we've heard there's been a lot of discussion about this nominee and the book that was entitled The Case for More Incarceration, for which Mr. Barr wrote the foreword. There has been concern about his opposition to efforts to lower mandatory minimums. And so my question to you is based on your experience as the mayor of New Orleans. Mm-hmm. During the time you were mayor, you saw a 60% reduction in violent crime. And as General Mukasey has talked about and others, one measure of the effectiveness of criminal justice policies is a reduction in crime.
Right.
So can you talk a bit about what it is that, as mayor, you did, and perhaps even best practices around the country that have led to a reduction in crime?
Yeah. Well, thank you very much for your question, and it was a powerful moment for our community when we changed the landscape of public safety. And I might add, we embarked on a plan that was comprehensive in nature. There was a law enforcement component to it, but there was also a human services and youth development component to it. And I set aside the debate between the two and said that we needed to do both. So our law enforcement component was a comprehensive reform of what was at that time a very broken New Orleans Police Department. And that comprehensive reform included weeding out corruption, dealing with a very brutal police force. It involved discipline and firing and remaking of how we recruited, how we trained, how we paid, how we deployed, how we used technology. It was broad-based. It was highly successful. We did not have the problems whatsoever because we also put our foot down and said we were going to have responsible and constitutional policing. So it is important in the context of the Justice Department. And when I took office, there was a Justice Department investigation of the New Orleans Police Department. And instead of fighting the investigation, instead of trying to delay the investigation, I worked with the Justice Department and presented my own far-reaching, far-ranging plan, which at that time went farther. We were prepared to go farther on a proactive basis than any department at that time had gone under a consent decree. That's number one. But number two, and this is part of the purview, because justice, in addition to its law enforcement responsibility, runs mentoring programs, programs funded by the Office of Justice Programs, in the old days, Weed and Seed. We also deployed and made full utilization of all of those initiatives, too, to invest in youth development, to expand recreation, to expand after-school programs, to expand youth summer jobs. It was not just law enforcement. It was not just human services. It was a combination of the two. So I think it's important to understand that justice has law enforcement responsibilities, but also justice has responsibilities with respect to investing in the community, investing in youth. I would point this out, and I think this is important. At the time, and this was during the Clinton administration, the Clinton administration worked cooperatively with us, both to help us pursue violent crime through gun prosecutions and drug prosecutions, but also invested through Weed and Seed and Office of Justice programs. Also at that time, you had the community-oriented policing program, which provided us with additional resources for police technology. So the lesson to be learned, and I would say this, the consent decrees that are out there, and this is misunderstood by people, a consent decree is by its very definition a voluntary agreement between a city and its police department and the Justice Department. And most of those consent decrees that are entered into have been entered into in lieu of litigation that the department had the right to do. So the idea that pursuing consent decrees is in effect a voluntary collaboration. And I think General Sessions was against consent decrees, but offered nothing in exchange, offered no other strategy in exchange. I'm just against consent decrees because I think that they negatively affect police morale, but didn't offer another approach. We need this nominee to indicate that he's going to be committed to constitutional policing, committed to public safety, but understand that public safety, we've learned, is not just crackdown law enforcement. It's something much more comprehensive. It's something much more proactive. Yes, you've got to prosecute violent offenders, no doubt, but you've also got to ensure that there are reentry programs that when people come out of jail, they're not apt to repeat. And that is part of, I think, a sensible, smart on crime initiative. Hope that helps.
And as a follow-up to your point, some of the best and most innovative initiatives we've seen in the last couple of decades on criminal justice policy have been the result of the U.S. Department of Justice funding innovation in a way that supports local law enforcement, local prosecutors, and local community groups to create the kind of collaboration that you're talking about.
There used to be a local law enforcement block grant program that provided money, which allowed you, because city governments are strapped always for resources, that created a way for you to invest in some innovation, some collaboration, some differential sorts of things. And I think justice can play a proactive, smart on crime role in helping make our communities safer.
Thank you. Mr. Johnson, you've testified about your concern about the nominee's statements that have been made in the past about the fact that there's no statistical evidence of racism in the criminal justice system. He did mention during his testimony yesterday and acknowledged the disparities between crack and powder cocaine enforcement, but did not acknowledge or mention any other of the disparities that we've seen in the criminal justice systems, such as arrest rates that relate to a variety of crimes, but in particular drug crimes, the disparities based on race in terms of who gets what amount of bail in the criminal justice system, and of course incarceration rates, which there are huge distinctions based on race in terms of the application of sentences. So if he is confirmed, what do you believe will be the ramifications or of his failure to acknowledge that, and what would you recommend he do if he is confirmed to acknowledge and to be informed about these disparities?
An individual to serve as Attorney General of this nation must recognize the long legacy of race disparity. And as AG, I would hope that he would really look into the credible research, and it will be obvious that in the criminal justice system there's a huge disparity. Some of that can be accounted for based on income, but much of it is accounted for based on the racial makeup of juries. It could be accounted for selective prosecution. It could be accounted for as relates to a myriad of things. And as the Attorney General, I will hope he would factor in that race is a problem. We are far from a post-racial society, and we must attack problems with a racial lens, because there is very little in our criminal justice system that's race neutral.
And just one more question, Madam Chair. I requested that if within a period of time, if he is nominated, if he's confirmed, that he would meet with civil rights groups to to understand the ramifications of any policies. He agreed to do that within the first 120 days. If confirmed, I think that we will all expect that he will do that, and I look forward to hearing about the result of those meetings, and thank you.
Thank you.
Senator Cruz?
Thank you, Madam Chairman. Let me say thank you to each of the distinguished witnesses for being here, for being part of this hearing. I appreciate your testimony and wisdom and judgment. Judge McCasey, let me start with you. You have served as a federal judge. You have served as U.S. Attorney General, as has Mr. Barr, and you have built a long and distinguished career in public service. Can you share for this committee, in your judgment, the importance of rule of law and the importance of having an Attorney General who is faithful to enforcing the law and Constitution regardless of party, regardless of partisan interest?
It's really the only guarantee that we have, because this country is defined by and is constituted by a law, the Constitution. It's not based on land, it's not based on blood, it's based on a law. It all started with a law. And that's what we've built this society on, the notion that you can have a society that operates fairly, in which neutral principles, neutrally applied, allow people to reach their maximum potential. If that's ever abandoned, if it's ever deviated from, if it's ever perceived to be deviated from, then we're lost. Then we have nothing to define us, because we're defined by a law.
Now, you've testified today that you know that Mr. Barr is a, quote, superbly qualified nominee, that he has good judgment, and just importantly, that he has the will to exercise that judgment despite pressure from any source. Can you share with the committee what, in your professional or personal experience, gives you confidence that Mr. Barr will once again well and ably carry out the responsibility of Attorney General of the United States?
Well, as I mentioned, he has had a past history of doing that when he served as Attorney General, notwithstanding that there was a desired result from the White House, and he kind of deflected it and, as it were, laughed it off. He is somebody who has testified here that, in view of the fact that most of his career is in the rearview mirror, he doesn't really have to concern himself with the possible negative consequences of resisting pressure from an administration. So that's an additional guarantee. But I think the person himself and who he's been over the years consistently really speaks to that. And it's not just a question of his having nothing to lose. I think that is the way he's constituted. As Professor Turley said, he's a law nerd, meaning he is devoted in a way that very few people are to what defines this country, and that's what he enjoys. That's his occupation and his preoccupation, and that is, I think, an excellent guarantee for the way he's going to approach the job.
Well, this committee in particular, I think you will find no criticism for being a law nerd. We tend to attract more than a few of them. Mr. Thompson, you likewise have a long, distinguished, honorable career, marred only by briefly being my boss at the Department of Justice, and I apologize for all of my errant mistakes since that time. Let me ask you the same question I asked Judge McCasey, which is, in your professional and personal career interactions with Mr. Barr, what gives you confidence that he will once again ably carry out the role of Attorney General?
Thank you, Senator, and I'm very proud to have you as one of my colleagues and former alums from the Deputy Attorney General's office. You've certainly acquitted yourself well. Bill Barr has a long history in the Department of Justice. As I said in my opening statement, he has a great love for the department. I think that may be one of the reasons he wants to return to public service. He has great fidelity to the department. But in addition to some of the sort of sterile constitutional questions that we've been discussing this morning, important but still sterile in my view, he understands the traditions of the Department of Justice. He respects the traditions of the Department of Justice. He knows the impact that his decisions will have on the men and women who are in the department, who are in the investigative agencies. And there are reasons for these policies. There are good reasons for these traditions, not the least important of which is public perception that justice in this country, investigative decisions in this country are carried out fairly, without fear or favor of what your status is in society, and most importantly, without political considerations. He understands this. I think this makes him superbly qualified to be, again, the Attorney General of the United States.
Thank you. Ms. Carey, you have worked with Mr. Barr some 2 decades. One of the things you testified about was Mr. Barr's busy schedule, long travel hours, and yet in the midst of it all, juggling to find time to be a husband and a dad to his 3 daughters. As the father of daughters myself, I know how difficult that can be with public life. Can you share with the committee some of what you saw firsthand about how he managed to carry out his responsibilities and still be there for his daughters?
Yeah, he was a tremendous father, as we saw yesterday, a grandfather. And as I said in my testimony, the fact that all 3 of his daughters went into the law is huge. My husband is hoping that our daughters do not go into the law because he thinks it's becoming an increasingly difficult profession. But to your question about his demeanor and the way he conducts himself, which I think is an example to his daughters, we were in Houston, and we were there for some events, and as he was hearing from all these victims of crime and people talking about how high the violent crime rate had gotten, can he please do something to help, he spontaneously turned around to me and said, "What do you say we stop by the Harris County Jail?" And it was not on the agenda at all. For security reasons, you would never tip off that the Attorney General was going to a prison. And the FBI basically kind of rang the doorbell for the prison and said, "We're here," and did an unannounced visit to the prison. And the Attorney General, the prisoners did not know who he was. Obviously, we didn't announce it. He went around asking these guys what their lives were like, what they do to get in here, what's for lunch today, where do you exercise? And as much of a law nerd as he is, this was a very compassionate side of him. He was not showboating. There was no press involved. And to me, it showed the way he could sort of shoehorn in a quick visit so that he could get back and see his family, but yet learn about what people's lives were like, see the impact, not just of the violent crime on the victims, but also on proposed reforms on the people who are actually in the prisons. And I would be willing to bet there are not a lot of attorneys general, present company probably accepted, who have been inside a cell block like that on an unannounced thing so that he could get back to his family, but also continue to learn the impact of the policies in a very real way.
Thank you for sharing that wonderful story. And I will say his grandson, Liam, has become a internet sensation.
Oh, you stole the show.
Not seen since John Roberts' son Jack did Spider-Man at his announcement, and he too had a moment of glory. But
right.
Thank you to each of you.
Senator Blumenthal.
Thank you, Madam Chairwoman. Thank you to every one of you, and thank you for all of your written testimony, which I will review. We have only 7 minutes, and as a matter of fact, we're in the middle of a vote right now, so I'm going to be quick with a number of you. First of all, Reverend Risher, thank you for being here today, telling your story so powerfully and eloquently, and making sure we understand that your mother and your 2 cousins would be alive today if that shooter could not get his hands on a gun. Dangerous person with a gun. And I assume that you would support the legislation that's been introduced to improve the background check system. As you probably, I'm sure you know, that shooter was able to take advantage of a loophole in the current laws. But more broadly, Senator Graham and I have proposed a bipartisan measure to take guns away from people who are deemed to be dangerous by a court after due process, and thereby keep guns out of the hands of criminals and other dangerous people. I hope that you can lend your voice and your face to supporting that legislation.
I would support that legislation, sir, yes.
Thank you very much.
Thank you.
Professor Turley, you and I are in agreement that the president can be indicted. I think we're in agreement.
Yes.
While in office, even if the trial has to be postponed. I articulated that position to Mr. Barr yesterday and asked him to agree with me, and he wouldn't. You implied this morning in your testimony that he did agree with it. Do you have some information that?
Oh, no, actually, I have no, I've never spoken to him about it. I was saying that if you look at the history of both Mueller and Barr, I would not expect that they would try to change this longstanding policy. From a constitutional standpoint, I've never really agreed with it, as I think we share this view. The Constitution doesn't say that the president's immune from indictment. An indictment goes to the president as a person. Impeachment goes to the president as an office holder. That doesn't mean that a president is going to stand trial during a term, as you've noted ably. And indeed, it's, as you also know, as a prosecutor, it's exceptionally unlikely that when you got to the point of an indictment that a president would actually face a trial, let alone incarceration, during that term. Where Bill Barr falls in that, I really don't know. When we talk about him being a great advocate of the unitary executive theory, this is not. I don't share Neil's view that even though I'm not a big fan of the theory, that it is so horrific. You know, he believes in clear lines, and I share that view of what's an executive function, what's a legislative function. And when we talk about the avoidance doctrine of courts and trying to interpret statutes to avoid conflicts, it's important to remember that same avoidance conflict protects Congress, where I tend to favor in terms of Article 1. Courts also avoid conflicts in interpreting statutes that might impede your own authority. So I'm not too sure where he comes out on this specific issue.
Let me ask you, and I'm going to ask a couple of other members. I am deeply disturbed, an understatement, by some of the president's comments about the FBI, about judges, about our judicial system generally. And shouldn't the Attorney General of the United States be someone who stands up for, you know, it's easy to say, I'm for the rule of law. But when the rubber hits the road, he should be defending all of those institutions. Do you agree?
I do. What I should caution is that I don't think that Bill Barr is the type that is going to take a public stance often against the president, but he is someone who I think will be quite firm in his support with the department. I don't know what the president thought he was getting with Bill Barr, but I know what he's getting. He's going to get someone who identifies incredibly closely and intimately with that department. And I think he will be a vigorous defender of it.
Judge Mukasey, let me ask you, and I know that you may wish to be referred to as general.
I don't. I've always been uncomfortable with that, even when I was in the position. I thought it was weird.
As Attorney General, as Attorney General, I was referred to general for 20 years, and I never was comfortable with it either.
Yeah, in the UK, they call the Attorney General attorney, which seems a lot more civilized and a lot more accurate, particularly when there are people in uniform around.
As Professor Turley pointed out in his testimony about the seal, the UK has a very different system, and I thought, by the way, what your history of the seal was really very pertinent in terms of showing the differences between the Attorney General as an advocate of justice as opposed to an advocate for the Queen or the President. But let me ask you, aren't you deeply troubled by the President's attacks on the judiciary?
I disagree with them. I think it is extraordinarily unwise for him to do it, and in that sense, I'm troubled. Obviously, there is or should be a political price to be paid for that, and I think we're in the process of seeing it paid to a certain extent. But there has always been a certain level of tension between and among the branches. How it's expressed and how civilly it's expressed is a different thing, and I think we're probably in agreement there. But there is always a certain level of pulling and hauling that's built into the constitutional system.
And are you not also troubled by the president's attacks on the FBI and the Department of Justice for that matter?
The FBI can function on a day-to-day basis without a rooting section in the White House or a razzing section in the White House. I think that some of these criticisms of the FBI may very well turn out to be warranted. So far as the department, that's a different story entirely, and I've articulated that. I think that the former Attorney General had no choice but to recuse himself. He did, and that was not something that was not a criticism that ever held any water.
Well, I want to, again, thank you all for being here. I have a lot more questions. Maybe I'll contact some of you privately. My time has expired, and I know the acting chairwoman and I have to go vote, but thank you all for being here today.
Thank you. Without objection, and on behalf of Senator Grassley, I would like to enter this letter from taxpayers against fraud into the record. So ordered. Thank you all for being here today and for your insight into how Mr. Barr would lead the Department of Justice in what it is a very challenging time. Excuse me? All right, he is in. Just as I'm getting ready to end this hearing, Mr. Coons, you are recognized.
Thank you, Senator Blackburn.
Just made it in under the wire.
Yes, ma'am. Thank you to the panel. I appreciate your patience. There have been, as you know, votes and other issues happening in other settings. Reverend Risher, we did have an opportunity to speak during the break, but I just wanted to reconfirm my sense of loss at what you shared with us and the fact that I had the opportunity to visit and to worship and then to travel with Felicia Sanders and Polly Shepard. And it was a blessing to get to meet you today, and I look forward to your upcoming writing for such a time as this and talking about reconciliation work together. It's important and difficult work. And I wanted to start, if I could, by asking both you and Mr. Canterbury, with whom I've had the honor of working on other issues, about background checks in particular. We talked previously about the ways in which the NICS system doesn't currently fully work to deny access to weapons to those who should, under the law, being denied access to weapons. Senator Toomey and I introduced a bipartisan bill in the last Congress, the NICS Denial Notification Act, that would make a simple improvement to how we enforce our current laws. If you lie and try, if you go into a gun dealership and fill out the form and say, I'm entitled to buy a gun, they run the background check and come back and say, we're really sorry, but you spent 5 years in federal penitentiary for armed robbery. We're not giving you a gun today. And you storm out. In my home state, nothing more happens. In his home state, because the state police conduct that NICS notification, they know that they can now go have a conversation with you about for what purpose were you purchasing this weapon. This bill, if it were to become law, would require notification, simple notification to a state or local law enforcement contact. And these cases, these so-called lie and try cases are rarely prosecuted at the federal level, partly because of a lack of knowledge, partly because of a lack of resources. Mr. Canterbury, I'd be interested, I'm grateful for what I understand is the FOP's support for the concept in the bill. I wondered if you'd be willing to advocate with Attorney General Barr, should he be confirmed, for the resources to enforce lie and try laws and to make sure that our NICS system is working as it should.
Absolutely. We've been very critical of the lack of resources for the NICS system and the fact that a lie and try normally goes without prosecution. So, we've supported that bill in the past. We're with you and Senator Toomey on that. And obviously, with that will come the necessary appropriations and authorization to enforce.
That's our hope. Reverend Risher, would it have made any difference in the Dylan Roof case if he'd been denied the opportunity to purchase a weapon?
Yes, it would have made a difference. I believe if he was not able to secure his gun at that particular day, that maybe the tragedy in Charleston may not have happened. One of the things that we're up against is the 3-day waiting period that I know that needs to be expanded in order to be able to have a complete background check. And I think things would have been different if those things were in place at the time he bought the gun.
Thank you, Reverend. As the co-chair of the Law Enforcement Caucus, I intend to work in this Congress, as I did in the last, to try and find ways that both parties can support that would strengthen law enforcement and our system of denying access to weapons to those who shouldn't have them. Professor Kinkoff, if I might, there was some vigorous back and forth about the unitary executive theory. We could have a very long conversation about this, but I'm just going to ask a focus question. Tell me specifically, the unitary executive theory is just that it's theory. It's not currently the law of the land. Am I right about that?
That's correct. In fact, the Supreme Court has rejected it repeatedly in every case, beginning with Humphrey's executor.
Yet you suggested that if we were to have an attorney general with a very expansive view of executive power, it might have some negative implications, and it might have some negative implications that would have some current relevance. Could you just explain that just a little bit more? My superficial and ill-informed view of this is that the founders did not actually say all executive power is given to the president, that it was the executive power, and then there are examples of ways in which executive power is actually shared with other branches. Historically, I don't want to get into a wonderful law nerd fight, but I'm interested in what are the practical implications if we have an attorney general who has a very broad and expansive view. My predecessor, Senator Biden, when he was Chairman Biden, although he was very complimentary of Mr. Barr, did express real concern about how broad his executive power theory was.
Right. So that reading of the executive vesting clause was argued by President Harry Truman in the Steele seizure case and specifically rejected by the Supreme Court. But that didn't kill it. It keeps coming back. Lawyers in the Justice Department, earnestly believing in it, applied it in the torture memo most infamously. So it's something we keep hearing. And the torture memo is a good example in the sense that it illustrates that much of what the Justice Department does never gets into court. Right? And so the Attorney General is such an important position because very often the Attorney General is the rule of law. It is only the Attorney General's willingness to not only stand up for what the Constitution says, but to recognize what the Constitution actually says. I have no qualms about William Barr on the first score. It's on the latter that I have real trouble. And so the Attorney General is a crucially important figure from that standpoint for issues we can't even begin to contemplate and we may never know about. But as to issues we do know about, that we can be quite certain, and even issues that may end up in court one day, that role is crucially important. Suppose the president decides he wants to tell the Federal Reserve how to run monetary policy. Now, that's something that might end up in court. But the Myers case, sort of the first case of the modern approach to the president's removal power, is a case where Woodrow Wilson fired Frank Myers, the postmaster first class in Portland, Oregon, right, while he was president. His presidency ended in 1921. The Myers case was decided by the Supreme Court in 1927. Can you imagine 6 years of a cloud hanging over the independence of the Federal Reserve? So even if ultimately the Supreme Court vindicates the proper view of the Constitution, we have potential enormous chaos in the markets. And that's just one example of one independent agency and the important role it plays in our lives.
You previously cited a list of independent agencies in Humphrey's executor, and this is a line of questioning I pursued with our most recently confirmed Supreme Court Justice. I am very concerned about how this view, which begins with a Scalia dissent and now has expanded significantly in terms of its adherence, what its real consequences might be. If I might, with the deference of the chair, ask one last brief question.
Very brief?
Very brief.
Because I've not voted.
Mr. Morial, about 67,000 Americans every year are dying of overdoses. Mr. Barr once said, I don't consider it an unjust sentence to put a drug courier in prison for 5 years. The punishment fits the crime. I've come to the conclusion we can't incarcerate our way out of the opioid crisis. Do you believe Mr. Barr will advance policies to help those suffering from addiction get the help they need without needlessly prosecuting and incarcerating large numbers of low-level drug couriers?
I don't think we heard anything from him. I wasn't here yesterday or anything in his record that would suggest that. I think it's going to require strong congressional oversight. It's not if the way we treat the opioid crisis mirrors the way we treated the crack crisis, we're just continuing the ill-advised policies of mass incarceration. And they certainly do not work, particularly for the user class. The user class, and what we did in the crack cocaine crackdown is it was users who were incarcerated for 18 months, 2 years, 3 years. Sometimes they repeated, and they went back to jail a second time. And the opioid crisis is an opportunity now that we're losing 60,000 people a year, more than we're losing to gun violence, to break from those policies and treat the opioid crisis for what it is. It's a public health crisis, just like the crack and cocaine crisis. These are people with deep problems of substance abuse. It's not to exonerate the pusher. It's not to sanction it, but it is to come up with a more intelligent approach. So I don't know if the nominee is there, and I think that this Congress and this committee is going to have to force him to get there.
Thank you, Mr. Morial. Thank you to the whole panel. Thank you to the chair for your forbearance.
And we thank you all for helping to give us a clearer picture of what you perceive to be the judgment and the understanding and the commitment of Mr. Barr. And this concludes the hearing to consider William Barr as Attorney General. I will remind the senators that the record will be open until 5 p.m. on January 22nd to submit questions, and we request your timely response. This hearing is adjourned.
All right, folks, thank you very much for joining us and choosing us as your stream of choice. So this is the second step right before the committee actually votes as a recommendation to Congress that Barr should or should not be confirmed. So that vote should be coming probably within this week, the end of this week, maybe even until next week. So make sure you guys stay tuned live here at Golden State Times. If you are new to the channel, subscribe and also click that notification bell. Thank you so much for joining us and choosing us as your stream of choice. Thank you to the moderators for keeping the chat clean and enjoyable for everyone. We hope that you guys join us next time. If you guys want to check out more videos on our channel, please do so, and make sure you guys share them and all that good stuff. Also, make sure you guys check out our website, goldenstatetimes.com, goldenstatetimes.com. We're going to have a whole bunch of new articles coming up on there because we're going to have a few new writers that are going to be writing on a consistent basis on our website. A lot of good articles, a lot of good people bringing up good points and covering everything that has to do with politics and news and stuff like that. So make sure you guys check it out at goldenstatetimes.com. Again, that's www.goldenstatetimes.com. Thank you so much, everyone, and I'll see you soon.